Freedom of speech and press, key court cases. Schenk versus the United States, 1919. Justice Holmes ruled for the majority that Schenk did not have the right to print, speak, and distribute material against the United States efforts in World War I because a, quote, clear and present danger, end quote, existed. Chaplinsky versus New Hampshire, 1942. In a key incorporation case, a doctrine defining what constitutes fighting words was established as a result of spoken words that, by their very utterance, inflict injury or tend to incite an immediate breach of peace that governments may constitutionally punish. These words have a direct tendency to cause acts of violence by the person to whom individually the remarks are addressed. However, the court has also determined that the use of obscenities aimed at governmental policy or worn on clothing as a means of protest do not constitute fighting words in and of themselves. Roth versus United States, 1957. The court ruled that obscenity is not within the constitutionally protected speech or press. In 1973, in Miller versus California, the court set criteria regarding what constitutes obscenity. It determined that if material appealed to the prurient interests and if it showed patently offensive sexual contact, and if it lacked serious artistic, literary, political, or scientific merit, it could be considered obscene. The decision on what is obscene was left up to community standards. New York Times v. Sullivan, 1964. This decision created a base definition of what constitutes libel, material that is written with malice and a reckless disregard for the truth. Slander criteria are very similar, but much more difficult to prove when charges are made against public officials. Tinker v. Des Moines, 1969. This decision established that students' rights are not shed at the schoolhouse gates and defined the students wearing a black armband in protest of the Vietnam War as a legitimate form of symbolic speech. These rights were later restricted in the student press case Hazelwood v. Kuhlmeyer in 1988, when the court gave school administrators the right to censor school newspapers. New York Times v. United States, 1971. Known as the Pentagon Papers case, the Supreme Court ruled that the government did not have the right to prevent the New York Times from printing information about the history of the country's involvement in the Vietnam War. Texas v. Johnson, 1988. Based on the arrest of Gregory Lee Johnson for burning a flag outside the Republican National Convention in protest of the president's foreign policy, the Supreme Court ruled that this action was a form of symbolic speech protected by the First Amendment. The Supreme Court decisions in this area have tended to tread a thin line. R.A.V. v. St. Paul, 1992. The court ruled that a city ordinance providing for stricter penalties for hate crimes was overly broad and vague and thus violated the First Amendment to the Constitution. Reno v. ACLU, 1997. The court ruled that the provisions of the 1996 Communications Decency Act, which punished Internet providers for making pornographic material available over the Internet, were unconstitutional because they were too vague.